those individuals, this morning's presentation will be focusing on those individuals that have a conservatorship already in place on their loved ones. And it's going to go over your rights and responsibilities and resources for them. There'll be segments of this that are resources for Los Angeles, because after all, this is being presented by NAMI Urban Los Angeles. However, the content that we're going to be sharing with you applies to the entire state of California. So irrespective of what county you might be in, today's presentation will be spot on for you. So with us today, we have the public guardian from Los Angeles, Mr. DeAndre Davis, and
Hello.
he's going to be
Hello,
filling
everyone.
in with everyone.
Hello.
Hi. So anyway, we want to thank the NAMI Urban Board of Directors, the director, Harold Turner, and other members for allowing us to share this information with you today. Working behind the scene is Araceli, our webmaster, who is really just doing the lion's share of work, making this all come together for someone. So we appreciate her as well so much. So understand that Gail and I are not attorneys. The information that we're going to be sharing with you today is based on information that she and I have accrued from attorneys and others over the passing years. Several successive public guardians from both Los Angeles and Orange County have previously reviewed this presentation, along with 3 mental health attorneys, all of whom have found the information in our presentations to be accurate. So today's meeting will be recorded live, and so for that reason, it will be made available for future review. A lot of the resources that we're going to be talking about today will be available up on the NAMI Urban Los Angeles website. We often get requests from people, how can they access the information that we're presenting? Just go to namiurbanlosangeles.com and it will be there. So we're also having to protect the privacy of your loved ones. And because it's being recorded, please do not mention your loved ones by name. We don't want to violate their rights, nor do we want to get in hot water for violating our California laws. So with all that, Araceli, if you can go ahead and get us started on today's presentation, I would appreciate that. Thank you.
Jim, can you hear me?
Yes.
Okay. I just want to tell everybody my internet is not the best. I'm in California right now. And so if I go out, Jim and DeAndre will jump in until it comes back on, because for some reason it's kind of going in and out. And I don't understand why. I'm not computer literate like that. Okay, next slide. Or tips. As a conservator, if you are the conservator and you're talking to somebody, the doctor or a facility, don't refer to yourself as their mother, father. Refer to yourself as a conservator. It elevates your status to a different realm, which they have more respect for you. Too many of these facilities, if you're the mom, dad, brother, sister, they don't really care. But as conservator, you have certain rights, and we're going to go over a lot of that. Also, empower yourself by taking the NAMI free family to family class. They have Zoom classes and they have in-person classes. That thing is so powerful. It gives you a better understanding of mental illness. The other thing is, this is extremely important if you're going to help your loved one get on the road to recovery. Keep 2 journals. One journal is for your loved one. It's their medications, what you observe, comments they make, and do not correct their comments. What you can do is say, wow, that's got to make you feel very uncomfortable. But if you start correcting their comments, they shut down. And then you don't know where their mind is. Even on the road to recovery, it's like they go 2 steps forward and 1 back, and it's very frustrating. So you want to be sure to know where their thinking is at all times. So don't correct them so they don't shut down. But at night, write those comments down in your little journal so that you will have a better idea how they are progressing, or if there's a problem that needs to be dealt with. Also, the second journal, and this is extremely important, you write down everybody you talk to, including if you talk to Jim or myself, the name, the date, the time, and what we said. Now, usually when you're talking to us, you can put LPS information pertaining to whatever. Otherwise, you're writing a thesis. I don't think you want to do that. But a lot of times people will give you information that is not valid. And there's a lot of myths going around. When you have something like somebody says, well, this hospital, the social worker, this hospital does not do conservatorships. If they are LPS designated by law, they have to. So you can call Jim if it's Orange County or me, Los Angeles, and we will direct you to the right person to go and report that. And sometimes a statement like that will end up moving towards helping your loved one get a conservatorship if they don't have it, or correcting the problem, whatever the problem may be. The other thing is get involved, get active, contact your state assembly person and your state senator, as well as your your supervisor, board of supervisors, and tell them what problems you're encountering and what's going on, because that's the only way we're going to change the laws. If they don't know there's a problem anywhere, nothing's going to happen. But there are plenty of problems and things that need to be corrected so that this moves slowly. All right, next slide. Next, the LPS conservatorship is the term used in California for involuntary mental health treatment. It's named after three legislators from about 1974. They had worked on this for several years to get it right. The Latterman, Petras, and Short legislators. The laws are a bit old, so they don't really reflect the scientific research and treatment that we have today, which back then, if somebody could gain recovery, many times they couldn't because they didn't have the medications that was going to work for them. But today we do, and a lot of these laws are changing, but they need to be changed a little bit more, and they need to be enforced, which is what they're not. Okay, the laws have been revised in Los Angeles and Orange County, and in 2026, January 1st, the definition for gravely disabled will change. It will include substance abuse as well as people with medical problems. So we're going to be revising these sessions, and you might want to listen to them again in January when this takes place. All right, next slide. The booklet is given when you get the conservatorship. You should be given a booklet helping your loved one. And you can find that on the internet. DeAndre, is that the new one that they are now giving, or is that the title of it?
That is the title.
Okay.
We also still need to revise our the booklet that we have on the DMH website to include the new codes and the new language and the LPS code.
Oh, okay, good. Thank you. All right, next slide. The essence of an LPS conservatorship, and this is strictly for a person with serious mental illness, is it mandates medication. Medication is vital to put the chemicals back in the brain to help the brain to heal. And we're going to go over medications and suggestions as to what you can do. And by the way, everything we do is suggestions. You are in the moment. You know your loved one better than any of us, and better than the doctors too, many times. So when you make a decision, it's your decision. If it doesn't work out, don't blame yourself. Go back and redo it. Your loved one was not born with a tag on his toe, instructions how to raise them. So if you have to blame somebody, blame your loved one for leaving that instruction behind when they were born. Next slide.
DeAndre.
Yes. So the Norwalk Mental Health Court is in at the Norwalk location. The Norwalk Mental Health Court Department A is the courtroom where the LPS conservatorships are established. It's actually Department A and B. The judge for Department A is Judge Scott Heron, and the judge for Department B is Judge Renee Gilbertson. Um, both both the LPS and also Care Court is also handled by these judges as well. But um, our most senior judge is Judge Heron. Judge Gilbertson is fairly new, but they're both very family forward and love to see family connected with their clients or with the conservatees. Sorry. Next slide. Okay, so the types of conservatorship, the types of LPS conservatorship. There's the conservatorship of the person. Um, that's when the doctor initiates the conservatorship proceeding. So, like Gail said, if your loved one's ever placed in a hospital on a 5150 hold, that doctor at that designated hospital is the one that would initiate the conservatorship proceedings. At that time, that's when the family members, that's the most important time is for the family members to provide the doctors with as much information about the person to help the doctors in there and not only their assessments but also in completing their declaration of conservatorship. Then there's also the conservatorship of the estate. The person has asked the public guardian to help get the estate. So routinely, a private conservatorship would only entail the person, meaning that the family member would have rights to address any and all situations with the person, with the individual body. The estate is the person's finances. And so, in order to become conservator over the finances, the court does require the individual to be bonded. But in most cases, with clients who are usually just on public benefit, the bond issue is not much of a problem. But at that point in time, at that conservatorship hearing, it is important to ask to have estate powers as well, because that'll help you navigate the benefits for your loved ones.
And also, if I can add on that,
Sure.
if they're just getting SSI or SSDI, you really don't need the conservatorship of the estate.
Yes.
A representative payee will do.
Mhm.
And that's the treating doctor at the hospital can fill out the form for representative payee, and you give that to the treating doc or give it to Social Security, and open up a bank account in both their name and your name, and it will be recorded to the IRS as their income, but only you will have control of that account.
Yes. Yes. Next slide.
Next slide.
Succession.
I'm sorry.
I can take it. Succession of conservatorship. So a conservatorship can be changed from the public guardian's office to a responsible party anytime during the year. The conservatorship can be changed from a responsible person to the public guardian. It can go either way. Either if the public guardian is the conservator, we can approach the court and have the court appoint what would be called a successor conservator over our office. So that would take the authorities of the conservatorship and give them to the family. We have also had situations where the family member may be the conservator, and it may be a bit overbearing or a bit too much for the family member. We've also had family members who says I'm unable to continue as conservator, and they approach the court, and then our office can be appointed as conservator. When we have those types of conservatorships, our office is still involved with the family member. If you're not the court appointed conservator and it's the public guardian, we are more than happy and more than willing to work with family to help out with the best care and treatment for their family. If you are the current conservator, and or if you're not the current conservator and you wish to become the conservator, you can write a letter to the Norwalk Mental Health Court, addressed to either Judge Herron or Judge Gilbertson, and request for a change of conservator. And the court would then calendar a hearing and would hear, the court would ask the public guardian to communicate with the family members, and if appropriate, then we would make the recommendation to go ahead and allow the family member to step in as conservator. But ultimately, it's the court's final decision as to who would be appointed as the conservator. Jim, you want to add anything?
No. I think you've nailed it. Thanks.
Okay, thank
I do.
Oh, Gail does, of course.
Actually, the one thing that I'm going to ask you to do, if the public guardian is the conservator, please be respectful of their time. If you're the conservator, you're handling one person. They are handling 50 to 75. The time, it varies on the time. It's very time consuming because they have to go out and visit these people. They have to make sure everything's going on. So if you call that public guardian and you spend an hour telling them how they were born, how they were raised, and all that, they don't have time for that. Have your questions or your points right away so you can cover them and not go on. The best way actually is to email the public guardian.
Yes.
If you are respectful of them, they will take your call when it's necessary. I mean, when you really need them. But if you abuse that time, you're going to look at that and go, I don't have an hour for this right now. And, they do their best to work with you. So please be respectful.
Yes. Thank you, Gail.
You're welcome. Okay, who should be the conservator? There's pros and cons for each. If the public guardian is the conservator, they're able to place a person in a state-approved facility, and the hospitals can't push them around that much. It's also less stress for the family. And sometimes when you're at court and you want to be the conservator, and the person, the client says to the judge, I don't want them as my conservator, then the judge will respect what they want and give it to the public guardian. And I'll just tell you a quick little story. We had one fellow who was a strapping young man, and his parents were little bitty. And he gave the conservatorship to his parents. And he says, Your Honor, I don't want them to have my conservatorship. They beat me. I mean, these little bitty parents. And the judge says, okay, we'll hear this in another 30 days. 2 weeks later, he called his mom and he says, if you're nice to me, I'll let you be my conservator. She said, I don't want to be your conservator. You're not nice to me. Before they went to court, Mom, I'll be real nice to you if you'll be my conservator. And so they took over.
I believe we lost her.
I think we have.
Yes,
Yeah.
if anybody wants to step in.
Yeah. I can step in. So the as far as the pros and cons of being the conservator is,
When you do that,
I think she's coming
you,
back.
you have less with
Gail, you're cutting out.
Oh, I think we lost her all the way.
I think so.
One of the pros of being the conservator is that the family member will be able to place a person in state-approved facilities. One of the pros of having the public guardian. My office, we have a large network of treatment facilities that we work with that are under contract. And so we have kind of an internal team that we work with in DMH to kind of help with sharing documentation, some of the medical notes and things like that that need to be shared between facilities in order to accept an individual. Also, with having the public guardian act as a conservator, It does take a lot of the stress away from the family members. Um, we do care for our clients as if they are our own family members, but we don't have that history that families have with the stressful situations. And so we have, if a conservatee becomes challenging and argumentative, we don't have that kind of historical argument back and forth with the client. So we can kind of address that more on based on the needs of the person and more objectively, and not be so emotionally tied into it. So it does give the family some relief to have the public guardian kind of step in that role for them.
Right.
The,
Yeah,
go ahead, Joe. Yeah.
DeAndre,
Mhm.
is that now called bed management instead of ICD?
Yes, it's now called bed management. Yeah.
Okay, just want to verify that. And the other thing, the negative is you don't have any control of the medication.
Yeah.
Now, if there is a problem, you can request a medication review and ask the public guardian if they could, if they're the conservator, if they could do a medication review, because we do have some psychiatrists which will put a person on a smorgasbord of medication and they are all over the place. And that should not take place, but it does. I mean, it's the world is not perfect. I wish it was, but it's not. And thank you, DeAndre, for taking over.
Sure, sure.
Next slide.
So you might ask yourself if you should consider being a conservator. And of course, all of you today are allegedly all conservators. So the pro on that is that you have direct contact with the doctor. You'll be knowledgeable about what that doctor is doing with your loved one and prescribing and so forth. And I should add that in this situation, your responsibility then is to work with the doctor to have conversations and discuss the medications, and develop that level of communication for the best treatment for your loved one. Also, you have the ability to reject inappropriate treatment facilities or the medications or the treatment places. In terms of rejecting medications, it really should be for a very valid reason, such as if the individual maybe has a allergic reaction to Haldol. It may, in some individuals, cause their tongue to swell and cut off their airways. And so that would be appropriate to tell the doctor that you are not going to allow Haldol to be in this treatment regimen. However, you have to be very careful. If it's just kind of a flippant attitude, well, I don't like that medication so well. If you get in the way of the doctor's treatment process, they may take you to court and have you removed as conservator. So again, the real focus here is to work with your doctor for the care of your loved one. The downside is that when you're the conservator, your conservatee manipulates you. They will hound you unmercifully to buy them things that you may not want to buy them, or to buy things they just don't need. And so consequently, you just have to be able to shoulder that. Also, that when your loved one's in a hospital setting, hospitals quite often try to push you around and discharge a patient to a facility not appropriate for the level of treatment needed for recovery. Understand that as a conservator of your loved one, you have the right, when a hospital tells you that their facility is going to transfer your loved one to a different hospital or location, you have the legal right to go to that facility and look at it to see if it's appropriate for the needs of your loved ones. They cannot just arbitrarily, pull your loved one out and move him. And this happens. And, I have found this to be something that I personally have experienced. And because I had shared with the hospital that my conservatee was on a conservatorship, I called the head of the hospital and said, "You're in violation of law, and I want my son back today. I won't tolerate this, and I think this would be in your best interest to get him back." Well, it took me a date, but they brought him back. So you have to stand firm, always be polite, but just know that you have the right to determine where your loved one's going to go or not. Next slide, please. Gail, you want to start this one?
Okay. Sure. Liability for the conservator. As a conservator, and that's the law up above, you are not by law liable either civilly or criminally for anything the conservatee may or may not do. And that's really important. If you have a oh, what is it? Have one of your senior moments, Jim.
Oh, that's okay.
I think she went out again.
Uh-oh.
She's frozen. If you want to take over, Jim.
Sure. I'll just one of the concerns that some of the new conservators have that I've spoken to in the past, or if they're considering being a conservator, they're apprehensive about the fact that they may be held financially liable for.
Yeah.
They may be held financially liable for any of the expenses that their conservatee may encounter or accrue, and you are not. By law, you're neither liable civilly or criminally for anything the conservatee may or may not do, nor are you financially responsible for the conservatee's debts. I've had situations where my conservatee did some damage around a board and care years ago, and while I'm not financially responsible for that, I'm also recognizing the fact that we want to keep in the good graces of the board and cares or wherever they're at. And so I did cover those expenses. But if something goes really wrong, just the law is on your side to protect you from that. You're there to help them. You're not there to be financially liable for them. Anything that you would like to add, Gail? If you're
No, I think you covered it, and I apologize for my internet going in and out. Next slide.
Fine. Next slide. Okay.
Rights and responsibilities of the conservator. Your powers as a conservator are to approve or disapprove treatment, placement, and medication. And those are pretty powerful. So when the bed management facility gives you recommendations of where they can go or suggestions, they usually give you 3. I suggest that you go and tour all 3 of them. If you find there's a problem with them, because you know your loved one, you can say no to that, but you should have a good reason. And I'll give you some examples. One fellow didn't want anybody within 6 feet of him. You know, you're in my space. Keep in mind, he's not really totally medicated. The one facility they had suggested, there were 4 people to a room. Your only privacy was a hospital curtain around your bed. And I mean, they were crowded in like sardines. That would not have cut it. Another one, they're selling drugs right across the street, and that wouldn't have cut it. Another one was it was for low functioning people. And this person was pretty bright, but suffering at the time from mute schizophrenia. So that one would have freaked him out. So once that was reported, this is the reason why none of these will work. They came up with 3 other ones, which were far more appropriate for the patient. But when they did their investigation and the person's talking, it's understandable that they would think that they are not so sharp on this. Okay, the medications. This is very important. If a doctor gives you a smorgasbord of medications, you can ask that doctor, so which one of these is really going to work? And have that discussion with the doctor and tell them basically what you would like is to find which medication works the best at what level before you start giving this smorgasbord of medications. And the worst I've ever seen was 13 psychotropics. And the person was in the hospital. So I called, when I found out about that, I called the CEO of the hospital and took care of it right away. That didn't happen ever again. All right. Those are things that power to approve or disapprove, but you do it politely and nicely. And then you should be okay. You also have the right to change the doctors should there be a problem with the doctor. All right. Jim or DeAndre, you want to add anything?
I'd like to jump in. and that is in a current setting that my conservatee is in. Uh, it's a remarkable setting. They have accolades and awards and everything else. However, they sent me a form for me to sign that just basically intimated that they wanted to have me sign the form that was saying that there would be all these types of medications that they may or may not provide to my conservatee. And here's the whole list of different types of symptomologies that may, may not be appropriate. It may cause him problems and so forth, or it may not. And they just like carte blanche, just have me sign this. So whatever they decide at the moment that they should want to provide to our son for his care, they could do that without even informing me of the medication. And I sent back to them a notice that said, as a conservator, it's my responsibility as mandated by the courts and the welfare institution codes to work with the treating doctor and to have conversations with that treating doctor to determine which medications are the most appropriate for my conservatee. And so for that reason, I really cannot sign this form, but I will work with you to my best of ability and in a very timely manner. And I look forward to that experience with you, and just send it back to them. Don't ever just allow them to have you sign something carte blanche for them to prescribe any medication without first advising you and having a conversation with you about that. Next slide.
Oh, that was good.
So this is all of us.
Yeah, okay. DeAndre?
Okay. So conservators have rights. So conservators do have the right to speak directly with the treating doctor. Our office, as public guardians, we oftentimes require our staff to only speak to a treating doctor, not a social worker or a nurse practitioner. The social workers and nurse practitioners have good information and good day-to-day information on how your loved ones are doing, but the doctors are the ones that can actually write the orders and make the medical decisions for your client. So I would encourage you guys to develop a relationship with the treating doctor, have contact numbers with them, even figuring out when their office hours are, when they're available on site, just so that you can develop that rapport and you have a better chance of speaking to that doctor at a time when you need them.
Okay. You can go ahead and take it. We'll just add to everything.
Applying for SSI and SSDI, Medi-Cal and Medicare, and VA benefits. What our office as public guardians, we apply for these benefits because we have powers over the estate. But like Gail mentioned earlier, facilities can become representative payee for these benefits, and to cover for, especially with the Medicare and Medi-Cal, to cover for the cost of the medications, also the cost for the services that your loved ones are receiving while they're in the facilities. VA benefits, I've worked with VA benefits, but I'm not as familiar with the internal workings of the VA. But for our veterans that are connected, service connected, they have a lot of benefits, and being able to get a hold to the VA and to figure out who their fiduciary is really helpful in providing care for your loved ones.
Right, with the VA benefits, the
Yeah.
VSO is usually one of the best people to go through. They'll give you lots of information, and decent housing is available for veterans.
Yes, yes. Yeah, the VA has a lot of contracted facilities in their network as well.
Mhm. Okay, you can also have private insurance, Medi-Cal, and Medicare. So if somebody tells you, oh, you can't have all of them, that's a myth. You can, and the more the merrier. Now, some programs like we were listening to Linda yesterday, CareCourt is financed by Medi-Cal. So not the other ones. And some, but they are billing private insurance now for care court, and I think for AOT also. So hang on to that insurance. If you're paying for the insurance, for private insurance, if you want to drop it, you can. But between Medi-Cal and Medicare, you have pretty darn good insurance for your loved one. I'm going to go back to speaking with the doctor directly.
Yeah.
Again, it's like talking with the public guardian. I understand, because I've been there. When you're stressed, you want to just release everything. And it's hard to believe that, wow, your kid's going through this. Well, they've heard it all before in one form or another. That history, symptoms, and gravely disabled paper that you put together, that's powerful. But on a day-to-day basis, when something's happening and you need to let that doctor know, for instance, if they're developing tardive dyskinesia, that's a good time to talk with the doctor. There are medications to help that. Also, they might have to trim down the medication that they're on or take them off of it. But keep it to the point and short, sweet, and be done. The doctor doesn't want to hear a whole lot of conversations. They just don't have the time. So be respectful of people's time. Jim?
I think we're good on this. You guys have nailed it.
Okay. The conservatorship, the California Welfare and Institutions Code 5358.5. This is really valuable. As a conservator, you have the right to have your loved one hospitalized when you deem it necessary. And if you are the conservator, do not wait for them to decompensate to harm to self or others, or become gravely disabled again. Your job is to keep them on the direct format of recovery, not to let them, oh, gee, they're not doing good, they're not taking their medication, what can I do? You have the power to get them back in the hospital. The hospital is the only place that can force medication. If they're in an IMD, they cannot force medication. So you can call me if you want to. You can call Miriam Brown with the Deputy Emergency Outreach and Triage. If you don't have success with that, call Connie Drexler. If you don't have success, call me. We will get it done. Because even if it's been a week and they refuse their medications, they can go down quickly. Some go down slower. But you want them back on the medication.
Okay, evidently she's cutting out.
Um,
All right,
so yeah,
just go to the next slide.
yeah.
Full code. It gives you the power to request police transport to put them back in the hospital. The sooner you do it, chances are they can go to the hospital, pop a pill for them, they're good to go. The longer you wait, now we need an IMD because their brain has not been healing. It's kind of started to deteriorate again. They may have to go into an IMD for a few months or something like that. So do it quickly. Don't wait. I really do get aggravated when a conservator calls me, and I mean, it's a long time and they're doing this, they're doing that, they're violent and everything else. I get frustrated because you had the power and you didn't use it. You have to be a very active conservator to make sure that they are reaching recovery. And with this, I'm going to add one more thing, which I learned yesterday. When they go off the conservatorship, care court can jump in and take it from there to help them for the next year, 2 years, whatever they need to continue their recovery and with help. Okay, anybody want to add anything? DeAndre, I'm waiting for you.
Yes, when you do have your loved one hospitalized, like if they're having an episode, and for that quick stabilization, you still want to talk with the treatment team to see not only are we trying to get them stabilized, but has there been a significant change that may require a change in level of care? So, for example, if they're at your home, you know, you're the conservative person's living with you, and you're able to manage them there. If they're starting to get a little bit, you know, their symptoms are becoming a bit more than what can be handled at home, your communication with that hospital at that point in time will help inform them, so that you can get that person moved into a higher level of care. IMD facilities, like Gail said, they are not staffed to involuntarily medicate people in their hospital, in their facility. So they will send them out to the hospital. But if you have a loved one at an IMD that is being sent out to a hospital for stabilization, you want to have a conversation with both the hospital and the IMD to ensure that they're going to be able to come back to that IMD. There is a period of time. With our office, it's usually 2 weeks. If the person's been out of the IMD bed for 2 weeks, the IMD may move that person from their senses and fill that bed with someone else. So if you have a loved one that gets hospitalized for stabilization, you wanna not only get them stabilized, restabilized, but you also want to ensure that there's a place for them to return back to. That was it.
Andre, we'll let you take
Okay.
the lead on this, and then we'll come in with you.
Okay, so the California Welfare Institution Code 5358, the conservatee by court decree is gravely disabled. And Gail kind of touched on this a little bit, that the conservator can request police transportation to a hospital for treatment. Um, the hospitals can only place where medication can be forced. It depends on, yes, that's true, but it also depends on the level of care that your loved one required. So, like I said, in my example, if someone is hospitalized for stabilization and can be returned back into a open setting where medication is not enforced, then that can be done. But it's just, you need to be clear that that is the appropriate treatment setting for your loved ones.
Okay, I'd like to just add something. If they're in an IMD or a lockdown facility and there is a medical problem,
Yeah.
and if the IMD refuses to call to have them taken to the hospital, I'm not talking about um, the mental right now,
Mm-hmm.
then you as a conservator can pick them up and take them straight to the hospital if you need to go. Because some IMDs on the weekends, they use a skeleton staff, and many times there are people that don't even speak English, and they don't really know what they can do and what they can't do. So if there is a medical problem and you have to get either an ambulance out there or transport them to the hospital, do it. And then we'll deal with getting them back in that IMD after that. Don't wait. Okay. Jim, do you want to add anything?
No.
Okay, next slide.
Okay. So the authorization to detain and treat. So when you're appointed as a conservator, you're given specific authorities to detain your loved one and to treat your loved one involuntarily. And so in order for hospitals to follow through with those treatment models, you have to authorize them to detain and treat them. Um, this looks very similar to the form that we use in our office. Our form was a bit more expansive with, the with the WIC code that explains our authorities. But when you're appointed as conservator, you're granted certain powers. Powers 6, 7, and 8 are your most important powers. Those are the powers to place them in involuntary settings. It's also the power to force involuntary medication in the event the person does not want to take those medications. And so, by you giving the hospital the signed authorization to detain and treat, this is giving the staff the consent, your consent to detain and treat them as needed. Um, the hospital should still call you and let you know that they're actually going to detain and treat your loved ones. But this authorization is there on record so that they can do it as needed.
I just want to add, when DeAndre mentioned WIC stands for the Welfare and Institutions Code, which is the law that we're dealing with for LPS.
Yes, sorry, forgot about my we have a lot of internal language.
Yeah. Jim?
You have to go to the courts to receive permission from the courts in order to, let's say, provide your loved one an operation, or as I understand it, and there's so much controversy. I've heard so many different things about what you as a conservator can and cannot do on your own in regards to surgeries. I hear that yes, you can go to the dentist and there's no problem, and others say no. If they're going to stick a needle into the gum, that's invasive, and so you need permission from that.
Yeah.
One of the things that I would really love is to gain access to all the powers, so that as a conservatee, I would better understand what those powers are and what my obligations would be from that. Here in Orange County, there was a private conservator that was conservator of her mother, and the mother developed a emergency kind of a situation to where she needed an operation on her stomach, and the conservator, granted permission for the hospital to go ahead and operate on the mother, and she never approached the courts on that, or somehow the public guardian here in Orange County discovered that the mother had an operation and moved the process forward to have the conservator removed, the daughter, to have her removed as conservator. I never heard the final outcome on that, but never just assume that it's okay for an operation, unless it's a life and death situation to where, waiting a day might mean the difference between life and death. By all means, you can go ahead and have the operation, but if it's not life and death, be sure that you get permission from the courts for an operation to occur. And if you're not sure, then find out. Ask the courts. And that's about as much, I think, as I will, throw in on this slide.
I'm just going to add, if you do not have an attorney assigned to you when you were granted the conservatorship, then, and you're the conservator, I would go back to the court or write them a letter, and I would request that an attorney be assigned to you. So when you have any legal concerns or something like, maybe getting a shot of Novocaine, that you can contact that attorney. They're free. And that attorney will get you the permission. So you don't have to worry about, oh, I got to go to the court. How do I do this? They should assign you, the judge can assign you a free attorney for the year. And they usually help you with the reinstatement of the conservatorship as needed. So, DeAndre, did you want to add something to this again?
In LA County, the way we differentiate between the conservator's ability to consent to a medical procedure is just how Jim said. Anything that enters the body or pierces the skin, even flu shots for us is considered an invasive procedure, and so we have a form that we use with all of our facilities to get that covered. But it's what really becomes complicated with medical consent is the person's capacity to consent. And so there have been cases where our clients still had capacity and fully understood what the medical procedure was. And so they were able to verbally consent to that procedure. But like Gail said, we run everything through our attorneys, even if we know the person has capacity, just to be on the safe side so that we're acting in the best interest of a client and we're respecting their rights. But it's always best to run it through court. And if it's something that is going to require multiple procedures, it's best to have the court order granting you the authority to consent to that, and for in advance. For emergent issues that come up, it's just going to have to be handled that way through the emergent issue. But if someone has an ongoing medical condition that's going to require some treatment, it's best to get the approval, court authority to consent to any ongoing treatments for that procedure. And that way you don't have to go back and forth to court.
And DeAndre, it's my understanding, and correct me if I'm wrong, please, that while we as conservators have the authority over their psychiatric needs, that the conservatee still retains the ability to determine their own medical treatment, so they can consent, let's say, to go to the dentist and have a Novocaine administered and so forth.
Yes, that is correct.
Right.
That is correct.
But at some point, it might be safer to go through the courts first, and if there's a
Yeah.
question in your mind.
Yes, it would be, because although they retain the right, it's a matter of their capacity to agree to it.
There we
So if their mental illness is impacting their ability to fully understand and appreciate the need for that medical treatment, then therefore they lack that capacity to make a well-informed, um, um, uh, uh, to give a well-informed consent. Now, for example, I had a client a couple of years back who had stomach cancer and had capacity to some extent, understood what was going on, understood that he had stomach cancer, and understood he had previously had treatment. But part of his delusion was that that the cancer had been removed in a dream that he had, or something along those lines.
Uh,
So he although he was able to speak about the cancer, he was able to speak about the actual treatment and what needed to be done. His delusional thought process prevented him from giving further consent. So we have ended up having to go to court to get that authority to consent to proceed with the continued treatment.
Thank you for that.
Mm-hmm.
Thank you. Next slide.
There we go. So CalAble, for those of you that aren't familiar with CalAble or what that means, your loved one is on Social Security benefits, and primarily, if they're whatever housing they're in is covered by the Social Security payments that come in every month. I had a situation where the only available board and care at that time for my conservatee was quite a bit more expensive than what was normally paid. And so consequently, until I could get the Social Security allotments raised, I had to actually use my own personal funds to pay part of that rent. That would mean, I'm not sure, maybe Gail could talk about how that could potentially cause me some rift with Social Security, but that would mean then that the monies that I would be paying would have to be paid back by the conservatee. So to avoid problems with Social Security, what I did is I opened up a CalAble account, and then I took available funds and put them into the CalAble account. Any monies that leave a CalAble account, which is run by the state of California, that goes to pay for things like a board and care, then sidesteps any financial liabilities or any problems with Social Security in that regard. So you can actually spend more money than maybe what the conservatee is receiving if it's done through a CalAble account. And I would recommend that you go on their website and look at that. But let's take a look at the next page. I believe it's going to list a few items. Here are things that you can supply to your conservatee through CalAble funds. It's education, housing, transportation, employment, health, prevention and wellness, assistive technology, personal support, miscellaneous expenses. So there's quite a bit there that can be supplemented, through a CalAble account without any penalties. And they have a lot of tutorials and so forth online that will further expand this entire procedure. So CalAble is something that you might want to look at as a way to, supplement expenses. There's some things that you cannot utilize the Social Security funds for, but you can if it's filtered through CalAble. Don't ask me why they dreamt this up, but that's pretty much what I think we're trying to convey this morning.
I'm just going to add that if you're using your funds, let's say they're in a facility that costs $1,500 a month and SSI has provided for $1,300, that extra $200, Social Security SSI will now start to delete a 2-to-1. For every $2 you put in, they will consider another dollar that you have to pay back. And so instead of giving them $1,500, they will drop it down, or instead of giving them $1,300, they'll drop it down to $1,200. Now you have to put in $300. So use CalAble. Be cautious if you have SSI and Medi-Cal. And yesterday we learned that new applicants for Medi-Cal as of January 1st, that you have to keep their funds under $2,000. If they're single, if they're married, then under $3,000. So be cautious of these things. Okay. DeAndre, did you want to add anything to this?
No, you guys covered it.
Okay, next slide. Conservatorship of the estate. If you have the conservatorship of the state, it doesn't mean that they own $1 million. Sometimes, they could. But if you have the conservatorship of the estate, you can negotiate debts. If they owe a whole bunch of money, you can, and let's say they just got on SSI, and so they have a whole packet of money that came in. You can call those the debtors, credit cards usually, and say, okay, I've got X amount of money, but I have all these other people I have to pay. If you will accept 25 cents on the dollar or 10 cents on the dollar, I will write you a check today. But I also want you to send back that this has been paid in full, so you don't come back for extra money later on. You can handle criminal court cases. You can acquire a waiver for school loans. And believe me, that's a big one, because those Pell Grants, they go from, $3,000 all of a sudden, $5,000 and $7,000. And it's just crazy. It goes up. And you can cancel credit cards, which is sometimes a really good thing to do. Be sure you can ask the court to appoint you an attorney to help you with any of these questions and even dealing with some of these debts. But that's usually the conservatorship of the estate helps with these things. Occasionally you may have, the person has a lot of money, and then that money needs to be dealt with accordingly. And if you can get it into a special needs trust, that's helpful. By the way, the guru for a special needs trust is Jim. So if you have questions, he's the guy to call. Okay, next. Oh, anybody want to add anything? No?
Yeah, no.
Okay. DeAndre?
Okay, so the conservator must have court approval. We kind of covered this already with the invasive procedures. So again, all invasive medical procedures must have court approval. Also, if in the event of so all conservatorships are first established by the Office of the Public Guardian. Now, if you have become the private conservator and during your reappointment of the conservatorship, and you find out that there's a new medical condition going on with your loved one, you should bring that problem to the court's attention. That way, the court can give you court approval to address those new medical problems in advance. So, for example, if someone has ongoing diabetes and requires insulin shots now that they didn't previously require, you can bring that to the court's attention, and the court would be able to grant the authority to provide that insulin because it's a known medical problem. Next slide. All non-emergency invasive procedures must be approved by Department A or Department B. We have now have 2 LPS courtrooms. No experimental treatment is permitted. This is important. During COVID was the first time when this really became an issue that our office had to address. There was a use of a medication to treat early symptoms of COVID that was approved on an emergency basis by the FDA, but it had not been fully approved. And so because it was not a fully approved medication, our courts looked at it as an experimental treatment. And so we were not allowed to allow our clients to, we weren't allowed to consent to the use of that treatment. Now, in a situation where the client had capacity and could understand and speak with the doctor about it, you know, that's between the client and the doctor, because he still has that capacity and that authority to consent to it. But as a conservator, you cannot consent to any experimental treatment. Request all medical insurance issues to be approved by Department A. So again, you're conservator of your loved ones because of their mental illness. But if they have ongoing medical issues, please disclose those to the court so that the court is aware of it. And like I said, you can get the ability to consent to treating those known medical issues through the court.
DeAndre, can you address electric shock treatments?
ECT, electric shock. I forget what the C is for. Electric convulsive therapy.
Yes.
That is, you must have court approval in order to have those ECT sessions for any conservatee. If a doctor approaches you and say, we need a consent to do ECT, you must go to court. You must have that the court be made aware of it. They usually do not approve more than 15 sessions at a time. So if you do get the court approval to go through with ECT, and you're at that 14th session and they feel that they need more, you would have to return to court again to get additional therapies. Electroshock therapy, I have seen it used on clients at the state hospital, more so than IMDs, but it's usually when someone is either having extreme behavioral issues, or if they're just not responsive. They sit in a room and you stand in a corner for hours and hours at a time and not being responsive. The doctor may then suggest to have ECT.
Is it used for violence?
It is used for violence. Again, my experience, it has only been done for clients in the state hospital settings, where there has been a lot of eyes put on the individual and a lot of documentation on the behavior. So the need for ECT has been well documented. If ECT is being recommended for someone at an IMD facility, I would definitely want to have conversations with the treatment team to see if, you know, what other options have been tried and are available. But again, you cannot provide that consent without court approval.
Okay. All right, next slide. Go for it.
Okay. So conservator had direct contact with treating doctor. As a conservator, you have the right for direct contact with the doctors. You have the right to know all medications. You have the right of knowing what's the client's prognosis, meaning not only what are they diagnosed with, but what's the plan to get them better? You know, what are the chances of the person improving? And if so, what is the plan to get them to that point? Um, you have, and if one thing that one thing that I've told my staff in the office is, although you may have a doctor that's listed as the treating doctor, they may have attendings that work with them that may see your client on a or your conservatee on a daily basis. I know one doctor, he goes once a month, but he does have other doctors put eyes on his client multiple times within that month. So not only do you want to have the doctor's direct contact, but you also want to know who else works with this doctor that may be engaging your loved one.
That's good to know.
Mm-hmm.
Okay, and that's, be sure that's the law, that when a doctor says, when the facility says you don't talk to the doctor or they don't talk to the client, not the client, but the conservator, that is the law. And that's an important one to have, because you very well might have that stated to you.
Yes.
Okay, Jim, did you want to add something?
No, I just in fact made a notation of this particular slide. I think it's something that I need to have on my desktop at all times. Right.
We get a lot of times they tell you not, that you can't talk to the doctor. Okay, next slide. Criminal court cases. We're
So
working you, DeAndre.
I see. These are all my topics.
This one I know is.
Um, so if and this is kind of so ask if your loved one is ever arrested, um, and is in court and they have a pending court case coming up and they're currently on conservatorship, you should reach out to the public defender's office and request that the DMH linkage program be involved in that case. The mental health court linkage program is a DMH program that links people to treatment for their mental illness. A lot of times, people are arrested for crimes. What I've been told is called crimes of survival, or just they have a mental illness and they came into contact with someone and it turned into an altercation and now they're being arrested. Instead of that person being penalized for their mental illness and for having an incident because of their mental illness in the community, these are the types of situations where we want to direct people to get treatment versus having them incarcerated. So the court linkage program is that very program. So if you have a loved one that's been arrested, that's currently on conservatorship, reach out to the linkage program to try to connect that person to mental health treatment. The criminal process is still, the criminal justice system is the same as it's always been. And so by the time your loved one is looked at closely, it may have been a month or two down the line after the arraignment hearing and after the initial court hearings and things like that. But as soon as you know that your loved one's been arrested and you reach out to this program, that way they can flag your loved one sooner. You can also request for jail mental health diversion. So diversion programs are just that. Individuals with a mental illness, they do not want to penalize or incarcerate people simply because they have a mental illness. The diversion program is a program where if someone has a mental illness that has been arrested, they have the opportunity of being linked to treatment, and the completion of that treatment program could lead to their charges ultimately being dismissed and them not facing any jail time as a result of their because of the completion of the diversion program. This applies mainly to misdemeanor cases, although there are diversion programs for felony cases. Those become a bit more tricky, but the same rules apply. So you can be sent if you have a felony charge that is not of like a severe nature, didn't involve great bodily injury. Um, you can be sent to what's called felony diversion program, which is a 2-year commitment into a mental health diversion program. After the completion of that 2-year program, your charges can be dismissed. Um, the criminal court has first right for placements for treatments. Um, through the diversion program, they do have treatment programs that are specific for, for that program, for diverting clients from jail to into treatment programs. Um, in DMH, we have an emergent issue in jail right now where we have people who have been identified as having a mental illness, have been successfully conserved, but because they're not in a hospital setting, they're in a jail setting. There's usually a delay in getting them that bed into an IMD. So we have put in place a process to get our clients released from custody into a treatment facility while they wait to get into an IMD ultimately. So it's not necessarily a first right, but it is a different route to get them into treatment coming out of jail.
Is that treatment facility a lockdown?
So it depends because again, jail is not a hospital. So
Mhm.
they maintain clients, they maintain our conservatees. But if someone needs involuntary medication, most likely jail will not force that medication.
Mhm.
So if someone is needing that level of treatment, we'll try to steer them into the facility out of jail, into a facility that can follow through with that need for involuntary medication.
But is that facility a lockdown?
Yes, yes.
Okay,
We
because
do.
I know you have to go from a lockdown to a lockdown, so I wasn't, what do they call those treatment facilities? Do they have a name for them?
It's an acute setting. DMH has a couple of acute beds, acute facilities that we send our clients to. Um,
Oh,
But when they leave jail, if they're not presenting with acute symptoms, they would go to a UCC, an urgent care center. And from the urgent care center, they do further screening and then they direct them into appropriate treatment settings. If it's subacute, meaning like a PINMAR, I don't know if you're familiar with that facility,
mhm.
but it's a temporary secured setting while the person is being accepted into the IMD.
Okay. I have a question on the last one because when people call and their loved one's been incarcerated, I have them send the information to the jail doctor and request that the doctor initiate the LPS conservatorship
Yes.
and also request for the jail diversion program, whichever it might be.
Mm-hmm.
I look at it this way, the LPS, because it mandates medication, is like the insurance because the jail diversion is voluntary. And if they go into the jail diversion and then they don't cut it or go off their meds and then they're all over the place again,
Mm-hmm.
if you have the LPS, I consider that like your insurance policy because you can get them back in the hospital, back on the medication, and continue with the jail diversion program so they'll be successful. Now, yesterday, I'm not sure I understood it correctly. When James was talking about it, it was like the doctors aren't necessarily initiating LPSs when the person's in jail. Am I understanding that correctly?
That is a so the jail doctors are still initiating conservatorships. With having the diversion program in place and with it being voluntary, of someone voluntarily agreeing to go into mental health diversion is essentially volunteering to continue with, you know, voluntarily uh, agreeing to go into mental health treatment.
Mm-hmm.
That can be, if we have a conservatorship petition pending, that the public defenders are using that argument as saying my client is willing to go into this voluntary program that has these commitments in order to resolve their criminal case. That makes it difficult to establish the conservatorship, to say that the person beyond a reasonable doubt is gravely disabled and require a conservatorship because they're voluntarily going into this other mental health program. So we run into that issue a couple of times in court, but the conservatorships are still initiated by the jail doctor. So
Okay.
yeah, so that has not stopped. The issue is that by the time we get to our conservatorship hearing, usually the person has been released from custody. So the doctor that started the conservatorship um, referral may not be the doctor that appears at the LPS hearing to testify in the event that that's necessary.
All right. That explains it a little bit more. Thank you.
Uh-huh.
All right, Jim, did you want to add anything on that?
No, I really don't. I think it's
Okay. Possible treatment programs. Right now, we're blessed in Los Angeles because we do have usage of several different programs. The LPS is the one that is involuntary and it mandates medication. And we kind of went over a whole lot of things. The assisted outpatient treatment, you cannot be under the LPS and under AOT by law at the same time. So, but assisted outpatient is involuntary, but the treatment team, and it was run by Linda Boyd, is by Venice, I'm not sure how to say her last name, but anyway, they are well trained. They do pretty darn good work with helping the people to get recovery. So that's a pretty good program. Care Court, Linda Boyd is now taking that over. And again, it's a voluntary program, but they are, it's only been 2 years, but they're getting a lot of success. They have some cases where a loved one just, I'm not going to do it. They won't even let them see them. They'll just hide from them. So that's one of the big problems that they have with people like that. The home team is for the homeless, and it's an outpatient program, and they can initiate the LPS conservatorship. And usually it's the black robe effect with the judge, that the patient, if they have respect for the judges, oh, okay, the judge told me to do this, I'm going to do that. They really do respect that. And then the full service partner, all these others are involuntary except for LPS. It is a program. The difference between AOT and full service partner, AOT has one team for 10 people. Full service partner has one team for 15 people. So you get better, and I think they're a little bit better educated too, or, they just have more compassion and better ability to talk with your loved one if they're under the assisted outpatient treatment. So when you're evaluating where they should go, you can evaluate these. Now, what Linda said yesterday, when they get off the LPS conservatorship, be sure to apply for Care Court, because that can follow them for a year or 2 years, whatever they need. So they're not just, okay, they've done really well, now they're cold turkey. They have still another team to help them, guide them, and support them. Anybody want to add anything to this?
No, that they're like you said, we do have quite a bit of programs out there. Um, Full service partnership, home team. Home team's awesome. I worked a lot with home team, and Care Court being our newest option. And so there's plenty of plenty of programs that would fit different individuals and their needs.
Right. And Care Court is specific for schizophrenic diagnosis,
Yeah.
or that spectrum.
Yes.
Okay, next slide. Jim?
Yeah, I'm sorry. It's in regards to medications, it's really important that you as a conservator are fully aware of the medications and what they do. There's a website, and I go to this all the time, drugs.com. It's available as an app for your cell phone. It's also something that you can access via your computer. You can look for various medications in a variety of ways. And it will go over the medications. It will tell you what the normal range of medications provided are, what the side effects are, and so forth. the National Institute of Drug Abuse, NIDA, um, is oftentimes referring people to this website. So you want to know what medication is working or not working. What works for one may not necessarily work for another person. You know, you can always request a medication evaluation with the mental health court if you feel the medications for your loved ones aren't working the way they should be. And also in regards to medications, you should write into a journal. Again, Gail and I are really big on journals. Write into your journal the date of the medications when they were prescribed and the behaviors that you observe they're following with your conservatee. It's your place to see if the change of medication is improving their clarity of mind and thought processes. And as well, you know, future medications, future hospitalizations that may arise will really depend on these sort of journals that you're going to be keeping. So the goal really is to find the best medication for clarity of mind with the least side effects. In fact, that's what I just got through quoting to the hospital the other day.
Mhm.
But keep, you know, just keep a log on your medications. And again, you know, you should have a working relationship with your doctor. If there's things that you don't understand about the medication or you want to know more about the medication, reach out to your doctor. That's kind of your role. Your responsibility is to know what the medications will and can't do and get the doctor's opinion on the medication and so forth. And why is it that he's prescribing them? Gail, do you want to add to that?
I do. Okay. As private conservators, which you are, my suggestion is work to bring your loved one to as close as you possibly can to what they were before they got ill. And yesterday we were listening to James Kwan with the Public Guardian's Office say that that's not necessarily what the goal is of the county. It's to get them so that they're stable and they're doing well and not being hospitalized and incarcerated and all that. I look at that, this is my opinion, and I am not PC. That's a half-assed deal. I want them to get their life back the way they should have it and get their dreams back the way they should. So find the best medication that's going to work with them. When you're working with the doctor and they put them on that smorgasbord, use your powers and say, no, politely, I don't think so. Let's find one medication that works for them at what level. Now, I'm going to give you a list of medications, and this is what I'm sharing with you, what I have learned for others. There are people that have a mental health problem and people that have a serious mental illness. If you have a headache or let's say you have a migraine and I have a headache and I say, take my Tylenol, that's going to help your migraine. If you've ever had a migraine, you know it's not even going to phase it. It's the same thing with mental health versus serious mental illness. And the doctors for mental health and serious mental illness, they will prescribe Depakote, Seroquel helps you sleep, Ativan, Zyprexa, Abilify. Honestly, those don't do squat for your loved one. You need to up the ante. Now, out of 25 years, I've had one person call and say the Zyprexa worked for them. It does help a little bit, but not a lot. It's not enough where it's giving them back their life. The medications that tend to help, and remember, you've got to work with the doctors to find the best medication, because what works for one doesn't work for another. But the ones that you're going to have better successful with would be Invega. That's Indega. It is the identical chemical composition as risperidol, except it's how it's directed to the system. Risperidol goes to the cell and all the organelles of the cell, so you get a whole bunch of different messages. You tend to be tired. You don't tend to be so motivated. Invega goes more to the nucleus of the cell, so you tend to have more motivation, more energy. I would say my feedback that I get from people, because I always ask you, call and let me know, is 85% and more have good results with Invega. But keep in mind, there's about 15% that did not. So this is where you have to try one and the other, but work with your doctor. You're not prescribing, the doctor is. Invega would be one that has pretty good success, and it also has a shot. A comment on the shot, and your pharmaceutical companies will tell you this. They recommend every 4 weeks, but everybody metabolizes differently. If they're a fast metabolizer, you may need it every 3.5 weeks. If they're a slow metabolizer, they might go 4 weeks, 2 or 3 days, maybe even a little bit longer. That's why that journal, noting what you are seeing, is vital. Another medication is Vraylar. V as in Victor, Raylar. Now, Vraylar is one of 2 medications that helps with the negative side effects of schizophrenia. That's where things are taken from you. You become the walking dead. No smiles, nothing's thrilling. I mean, you're functioning, but you're really not there. Vraylar was the first medication to help with that negative side effects of schizophrenia. They all help with the positive too. Things that are given to you, the delusions, the voices, the entertainment in your life. The other one that worked, the second one, which is new on the market now, is Copenfy, Copenfy. Look up every medication on drugs.com so you know about those medications. But that also helps with the negative effects. Now, I deal with people in Florida as well as California. The doctors in Florida recommend, they really like Caplyta, Caplyta, and Copenfy. The doctors in California, I'm not saying they don't prescribe these, but I haven't had anybody who's been prescribed that to do well on those, or to even know how it does. But those 2 medications seem to do pretty good work on helping them. Another one is Latuda, Latuda. And I've had a few people on that, and they've had pretty good success. The other one is your standard, your gold standard from way back when, clozapine. And those are really, they tend to help a lot. So clozapine is the one where you have to do the blood test, and they do it, almost every day at the beginning till they can go later on. 1 out of 100 people might have a white blood count that gets messed up. So that's a precaution that they take on the blood test. But those are some medications that really, really can help people that I've gotten feedback on. Now, there are others, but those are the ones that I have gotten feedback, and people are really thrilled with those. But keep in mind, you can start one, and if it's not working, you can call that doctor and say, hey, this is what I am observing, and could we try another one? And that's all that I can say on that. And that's all my opinion. Okay?
So I'd like to jump in here if I may.
Yes.
Just knowing that there's probably some new conservators online here. Adderall is something that makes you feel wonderful. It's like, I guess, something tantamount to smoking pot. Really, that is sometimes prescribed for somebody that is very agitated and so forth. But know that Adderall is extremely addictive. Don't know that that's something you want to prescribe for somebody that is co-occurring, meaning that they're dealing not only with their mental health, but they're dealing with substance abuse addiction. We don't want to give another addiction. We don't want them chasing another high on Adderall. That's something, so you might talk to your doctor about alternatives to that. Another one is Wellbutrin. For those individuals that have problems, let's say with methamphetamines, Wellbutrin, which helps with depression, is something that can be crushed into a powder, and then sniffed up your nose, and it gives you sort of similar feelings as the methamphetamines. So Adderall and Wellbutrin are things that you need to think about. If they're in a hospital setting, it may be one thing for them to have Wellbutrin with a nurse observing, but a lot of times they'll want to cheek it if you're not paying close attention, and then take it out of their mouth later and crush it, sniff it up their nose. Sometimes hospitals will give it to the patients after it's been crushed and put it in some sort of like applesauce, and they can take it that way. It is effective for depression. It's a good drug. It's just unfortunately can be abused, and I just want to make you aware of it. All right, I'm done.
Okay, I'm just going to add one more thing.
Sure.
When we talk about substance abuse, a lot of people in California don't consider marijuana as a substance abuse drug. For our people, if they're doing marijuana, what it tends to do, it does calm the voices, but then it starts to make the person more irritable, agitated, to the point they become violent and they end up in jail. And I had one doctor call me because his son was having trouble. He says, well, I have to give him the marijuana because it calms him. And the kids in the background, I mean, the vocabulary was unbelievable. And I said, is that your son in the back? Yes, it is. And he's doing marijuana? Yes. That's why he's doing that. I mean, it's kind of like sugar, gives you energy, but then you crash after a bit. Marijuana is one of the most insidious drugs that you can take, especially for a person with mental illness. Okay, next. Wait, DeAndre, did you want to add something to all this conversation?
Oh no, I've just been listening. Like I never knew of that website, so I'm gonna jot that down, and it's gonna be part of one of my resources now.
That was compliments of Jim giving us that. Okay, next slide. Jim?
Sure. So this is a guideline for medication, is that you want to change, if you feel that a change of medication is necessary, you want to follow what's called or referred to oftentimes as a scientific method, where you change one variable at a time. If you're going to change a medication and you're changing one medication at a time, then you can observe over time, the changes to see if you're getting the results that you're trying to achieve. Again, working with the doctor on that. But you don't want to just change 3 or 4 medications all at once. Then you're never going to really know which specific medications are the most effective for treating your loved one's mental illness. Again, this goes back to journals, and again, Gail is real big on this, and I kind of follow behind her in that, is that keeping journals on your medications and who you've talked to is really important. But when it comes to medications, change one at a time, pay close attention to the behaviors that you're looking for to see if it's working or not, and keep a journal on that. Mental illness lasts for a lifetime as far as I'm concerned. And with medications, it's greatly improved. So you're going to find yourself over time ending up with different doctors, ending up perhaps in a hospitalization scenario. And it's really important that you have this wealth of information in your book. So when a doctor says, well, have you ever tried so-and-so? Gee, I think so. Let me look at my journal here. No, this is why that particular medication wasn't really working, and the doctor that I was with at that time felt that it wasn't working as well as this alternative medication. It's very important to keep track of things and how they're working for you. Yeah.
You covered it. Those journals are so valuable. All right, next slide.
Formularies. I can't talk yet. If medication is not listed in the insurance profile, this is something that Gail taught me. I have to give her all the kudos on this. You can request that the treating doctor write what's called a formulary to request a new medication. I actually was talking to a doctor at one point in time for my conservatee about the medication, and I said, "Gee, I don't think that's covered." He said, "Oh, that's no big deal." He said, "I can just write a formulary for that. It's just a brief one-page form I can fill out. We'll get that medication." So that's something you want to think about, is asking the doctor to write a formulary. If it's not being covered by your insurance company, the doctor can write a formulary and present that to your insurance, your conservatee's insurance company. Also, you can ask the treating doctor if they have any free samples to try a new medication. So instead of just going for a major shift and launching into everything, it may be that the doctor will work with you, give you some free samples to try, get your conservative on them, and then observe the behaviors to see if that's something that you want to incorporate full time. So, Gail, I'll let you finish that.
Okay. The free samples, if the doctor doesn't have a free sample, you can call the pharmaceutical company. And most pharmaceutical companies will do this. They will be sure that that doctor gets a free sample or several free samples to try. Sometimes the pharmaceutical company will want the treating doctor to call them, and all you have to do, the secretary can do that. It's not a big deal. Seek medicines that help with the serious mental illness, not mental health, because your loved ones have serious mental illness. And I really want you to don't just settle for okay. A lot of doctors will say, well, that's the best you're going to get, you know. No, keep working to find the right medication that your loved one needs for their treatment. If you have cancer, if you have breast cancer, you're not going to go to a prostate cancer doctor because that's just not going to cut it. You want to find what medication works for your loved one and bring them back as much as you can to their old self. Please don't just settle, because they will never stay on their medication. When they are as much as they can possibly be to their old self, they're going to feel better. They're going to like what they're doing. And chances are they'll stay on that medicine. And be sure to keep that journal data. That is really important. I can't stress it enough. And it will get you out of a lot of jams many times. Okay. DeAndre, do you want to add?
Not much, but just knowing the medications and knowing the reactions, especially with hospitals. I know jail and particularly likes to use the Invega,
There
the long lac, and although it's easy for them because it's they give it to them once and they don't have to worry about it for another 4 weeks. Sometimes it's not a medication routine that they have been on, and so they have clients that end up not doing well with that medication, and it's only because they're not on the routine medications they had previously been doing well on. So yeah, definitely keeping a journal, definitely letting the hospitals know which medications the person was currently on, is really helpful.
Mhm. And they have a form for the jail, which if there is a medication that works for your loved one, you can let the jail know this is the medication they need. They do the Invega as sort of like, okay, one fits all.
Yeah.
That doesn't happen. Like I said, about 15% of the people that call me, that did not work. But the 85% of the others, it was the miracle drug. So you never know. I like Invega for that reason, because it gives the greatest probability of success, but it's not all the time.
Yeah.
Okay, next slide. DeAndre, you have the honors.
Yes. So placing conservatees in a treatment facility. Um, ICD, now known as bed management, evaluates and suggests where the person should be placed. Now, they are reviewing, they're evaluating the referral that they receive to determine where the person fits best in the network of placement facilities. So your doctor, the treatment doctor that's working directly with your client may suggest an IMD. Um, they'll submit the referral, and bed management may say, you know what, I think this person may be better at a step down IMD as opposed to a full on IMD. You should still go with the recommended level of care that your doctor is suggesting, and you just need to speak with ICD and inform them as the reasons as to why that recommendation was made for an IMD over a different one. So they do evaluate and suggest the best place for them to go to, but it's usually fit with the facility. So not all of our IMDs are identical. Some IMDs are um, a bitter have more staffing ratios. We haven't some IMDs that are out in San Bernardino. That may be appropriate for some of our conservatees that may be required to register as a sex offender. So it just varies. The treatment is the same. They're all subacute levels of care, but it's just a certain IMDs. Some of them are situated a little bit different. They may be a better fit for that person. Tour every facility and ask questions. So, um, like I said, a lot of our facilities are, we have two out in the San Bernardino County area. The rest are located throughout LA County, mainly like in the southern side of LA County. Um, but yeah, tour the facility, get familiar with it, talk with the treatment teams, talk with the staff, facility staff, and get an idea of what that day to day looks like in the facility. As a conservator by law, your request for placement facilities must be honored as best as possible. So that goes back to my first point. Um, the the facilities are they're the same, but they're different. Some have, more of a um, the may have more of an open kind of feel to it. Like they have some places that have more outdoor seating areas and things like that. Versus, I know View Heights is more indoors. There's not much outdoor anything at that IMD. So, um, if you know that that's not going to be an environment that's going to work well for your client, and they may act out being in that setting, you don't want to get that confused with their illness, with their comfort versus their illness. So if someone is kind of claustrophobic and you have them in a facility that kind of elevates that feeling for them, then they may act out. So it's good to talk with the facility. Go look at the facility yourself and see if it's a good fit for your loved one. Write every contract. Is that right on every contract? Your express written? Yes.
Right. Do you want Jim to take that? He's got a good thing on it.
Well, let me escape, huh?
Well, I was just gonna say, just make sure you not only read and every contract that you sign with a placement facility, ask questions if you're not sure on what exactly it's that contract is saying. Even as a conservator for 15 years, I run across forms where I have no idea what it's for or what it's saying that I'm signing up for. And so, coming from someone that does this day to day for hundreds of clients, I still read the contract, I still ask the question. So simply because you're being given a contract saying this is required for your loved one to be admitted, ask the questions, get the clarification. Sorry, Joe.
No, that's great. Thank you for that information. Again, the last paragraph down here, writing on every contract that your expressed written permission must be given for any change in medication, treatment, and placement. That applies to your designated hospitals so that they cannot then just arbitrarily move. I've had, as an LPS conservator, when your conservatee is in a designated hospital, they cannot transfer them out of the hospital to any other location without your written permission on that. And again, I've had them do it anyway, And I've had conservatees call me and say, gosh, the doctor stood right there and told them not to transfer my conservatee, and they did it anyway. So you have to really be on top of this. And again, if they moved your loved one out, I always contact the hospital and say, no, bring them back. I'm not going to let that go forward. But down here, where at the bottom it says, right on every contract, your expressed written permission must be given for any change in medication, treatment, and placement. That's something that you should write down someplace. You should memorize that. For those of you that are watching on a Macintosh, if you look at your keyboard right now and you hold down the Shift and the Command key, and then you take your cursor, and take your mouse and move your cursor over this last paragraph and click at the top and then drag across and down, it will save that as a screen share to your desktop. Write that down on your contracts. Also, I always carry these Pentels. It says needle tip. And what that does is I take this with me whenever I have to go to the hospital for this very reason. And I start writing in between the lines with a little tiny print saying, my express written permission must be given in any change in medication, and so forth, as you're reading. And these are just things that prevent your conservatee from being taken to perhaps a hospital that is not quite the quality that it should be. Or perhaps, like I've had cases where the conservatee here in Orange County was an extreme south end of the county, I mean, way down south end, and their loved one was moved from one of our central hospitals to a Long Beach hospital, and before they could get on top of that, their conservatee was transferred yet again to someplace up in Los Angeles, all without the conservator's permission. So if this is written down on that paperwork at the hospital at the time that your loved one's put into the hospital, it brings to their attention, hey, we better not move this patient. Look what this conservator just wrote on it. So just that's enough. I'll let you go forward with that.
Well, that also goes for the medications, because sometimes they'll change the medication and you won't know. And you'll say, what's wrong with my loved one? He was doing so good. Well, they've put on something that isn't going to work for him or her. So that statement, and any contract you have, if there's something that bothers you about the contract, don't accept that when they say, well, that's what it means. If you're not sure, you can write on that contract, because this is an agreement between you and a facility or whoever you're dealing with, and you want to make sure things are clear. I'm going to add one more thing when you're touring these facilities. Take a list of questions, and questions like therapy. Do they give group therapy, individual therapy? How often? The foods, if your loved one needs a special food, will they be willing to do that? That you will be able to talk directly to the doctor when needed. Because some facilities will say, well, you don't talk to the doctor here. The doctor doesn't have time for that. Too bad. He has to have time. Another one to ask about is sex. How do they handle that? You really don't want to become, well, maybe you do, but possibly not a grandparent before they get out of that facility. So there are so many questions to ask. Think about it. What type of treatment? If they go off their medications, will they contact you so that you can get them in the hospital? Or will they call and have them placed in the hospital? These are important questions because they're there to help your loved one. And you want your loved one to continue to get better and better. Also, will you be able to take them out as they get better, to go out for lunch? I'll tell you, the first time my son went to an IMD, and they gave me 4 hours to take him out, like for lunch, get a haircut, whatever. Well, after 2 hours, it was a return to sender. Y'all can have them. I don't want them. But within about 2 or 3 months, Oh, he was coming home 3 nights a week with us, and we didn't want to take him back. I mean, it was so much fun. So the medication can help a person with the recovery, but without the proper medication, they can keep them. Okay, next one.
Okay, so placement and treatment via hospital. So the way
Didn't
we
we do this?
hmm?
Oh, I thought we did this one. Maybe
the
not.
the other one was more about placing in treatment facilities.
Oh, okay.
This one is more for about, what happens when they're in the hospital.
Okay.
So while the client is in the hospital, and being stabilized, let's use someone that may have been 5150 for, danger to self or others. So they would be hospitalized, and as they are stabilizing, the hospital would submit a referral to ICD, intensive care division with DMH, which is the bed management unit, or now known as the bed management unit with DMH. Um, the person can only be transferred from a lockdown facility to another locked facility. So any event that, like Jim's example, where, because this happens to me on the weekends, where a client may be hospitalized for stabilization, but they may be in a hospital that's not fully LPS designated. So what will happen is they will contact the next secured setting to transfer that client to for that stabilization. And then once they're stabilized, then they can move out um, into a lesser restrictive setting. But in that emergent situation, when they get that person to the hospital, they find out this person has schizophrenia, for example. That's not the right hospital setting for them. They're going to transfer them to another secured hospital. Um, IMDs is a secured facility where the hospital usually discharge first. It's kind of your hospital is your acute psychiatric setting. IMDs are your subacute psychiatric setting. So it's a step down from the hospital. It's when they no longer require that involuntary need for medication, meaning like hands-on forced medication. That's being done at the acute. The subacute is where the medication is being routinely administered and monitored, and the clients or the conservatees' behaviors are being monitored and documented daily. Um, as If a patient improves while they're in the acute hospital setting, they might skip the IMD facility. Those are more of our quick turnaround hospitalizations where they kind of went off the path on meds for a little bit. They started developing, some negative symptoms. A quick stay in the hospital, get them stable. They may not need to go back down to an IMD. They may go down to an ERS or a what we call a step down IMD facility, which is semi-locked. It's not, it's locked at night, but it's open during the day. But it has the staffing on site that an IMD facility has, but it's just they have more freedom to come and go. You guys want to add anything?
Yeah,
No.
here in Orange County, it's a little bit different. We have what are called TRCs, and Gail was telling me yesterday that they don't have TRCs in the Los Angeles County area. I thought, wow. Um, Primarily, for an example, here in Orange County, that is the difference is that um, when your loved one's sent to a hospital for treatment and they determine that your loved one needs long-term placement, they send them to what's called TRCs, and we have several TRCs here in Orange County. Um, and those TRCs can be for up to a year. And then from there, they also can send the individual to an IMD, and that is also for a long-term placement. So I think that in Los Angeles, it goes from the hospital straight to the IMD, whereas here in Orange County, there are the TRCs. What I want to say is that some of the some of the TRCs here in Orange County are excellent facilities. I think they should be proud of what they do, but sometimes it's just not the right modality. It's just not, it's not the right fit. And at least it hasn't been for my conservatee. I've seen other families go to the TRCs and they have a very good, rich experience where, for whatever reasons, my conservatee uh, had a different reaction to them and did not do well and was going to an IMD. And there's several IMDs, and I just wanted to highlight that there's a place called Riverside IMD. I think it's Riverside Behavioral Center is close to the right name, and they're phenomenal. I have a LPS LPS attorney that shared with me that there was another family that had a son who also was not doing well in some of the treatment facilities, but did extremely well in the Riverside facility, and when discharged, continued to do extremely well. So somehow the treatment modalities in these different institutions can have different impacts on different people. And I'm finding that the Riverside facility is just phenomenal for our son. And I look forward to his discharge because I have all the faith in the world. So I just think it's very interesting that there's not a one size fits all in the institutions that are out there. They're all, I think, quite excellent at what they do, but for some reason, I don't know if it's the personality or just the individual themselves, do better in some, than others. And so I just wanted to share that with the group. If you're going through treatment facilities that maybe aren't, your loved one isn't behaving the best or achieving the best outcomes, if there's the next time around to where they're going to go back into a similar facility, then you might look at an alternate choice. And I'm just finding that the IMD out in Riverside is excellent, and it's something that you might want to take note of. All right, thank you.
Jim, there's a question. What does a TRC stand for? That's it.
I suffer in answering that question.
I want to say transitional residential care.
It may be transitional recovery center. I'm not,
Yeah.
there is a specific meaning for it, and forgive me, I'm not real clear on that. And I should know it, and I don't.
DeAndre, oh, I'm sorry. Go ahead.
No, that's it. Go ahead, Gail.
DeAndre, I was going to ask you, is UCS, that urgent care setting, is that comparable to maybe a TRC?
No, it would not be. Because I too don't remember what the exact TRC stand for, but it's more of a like a transitional. That's why I mentioned Pinmar earlier. It's a secured setting that's kind of like, I don't want to say because the IMD beds are so hard to come by, because those beds are full. In order to get someone admitted in, someone has to come out. And the TRC setting, my understanding of it is that facility where they're still receiving the care and treatment. And if a bed does become available, they can move into that IMD. And in some instances, just being at that TRC level of care may be enough to get them, to move them out. Because the county hospitals, the hospital, the acute hospital is, those beds are, I don't want to get into money, but those beds are paid for when there is a medical necessity for that person to be there. Medical necessity and ready to leave are at two different levels. So although someone may be no longer meeting a hospital's medical necessity to remain in that bed, they may still need to be put somewhere. And that's where we have a lot of hospitals that discharge people when they are no longer meeting the quote unquote medical necessity for the hospital to keep that person, but they still need to be in a setting that's going to provide them with that treatment. So the TRC kind of is an extension of that hospital stay, where they can still get the medication that they would have got in the hospital setting while they wait to move into the next facility.
Okay. All right. Next slide. This is your specialty, DeAndre.
So treatment and placement via jail. So if someone has been found, someone has been arrested for a felony charge, and it was determined that they were incompetent to stand trial for that felony charge, the court may have a doubt declared, saying that, and essentially saying the person is incompetent to stand trial. They want to send this person to state hospital where they would get competency training and some medication management and treatment. During competency training, they're not working towards getting the person necessarily stable enough to live independently. What the state hospital is doing is they're working with the client to get the person to a point of competency to stand trial, which is pretty much understanding the basics of the court. What's the judge's role? What's the attorney's role? And making sure they understand the different pleas. That alone does not mean that a person is able to provide for their basic needs. But if someone is declared incompetent to stand trial for a felony, they will most likely be sent to the state hospital for competency training. And the maximum amount of time they can be held at the state hospital is 2 years. Right now, I believe the state hospital system is kind of going through a shift where they're kind of splitting the state in two. So everyone in Southern California area, the 2 state hospitals that Southern California residents will most likely go to will be Patton State Hospital and Metropolitan State Hospital. For Northern California, it will be Atascadero State Hospital and Napa State Hospital. And in some instances, maybe Coalinga State, but that's extremely rare.
Okay. A normal movement through the treatment facilities, generally speaking, you start out in the hospital. If they get the LPS conservatorship, then you can go to an IMD, which stands for Institute for Mental Disease. It's also a lockdown facility. Because remember, you go from lockdown to lockdown, either the jail to the IMD or the hospital to the IMD. Then you can possibly go to, and you can skip any of these, depending on the individual, how they're doing. An enhanced residential setting, which is a secure facility, but not a lockdown, like James said, or DeAndre said, you have movement where you can, you can check in and check out. Board and care is the least restrictive, but you basically, I did say that already, you have to go from a lockdown. Check out those boarding cares. Some of them are terrible. Some, I swear, are drug houses, and a few might be houses of ill repute. So be sure you check every single one and talk to the manager what goes on, what they do, how they help the person. Do they give medication? From there, they can probably go to their own apartment. If the person is older and you're getting older, it's not the best idea to have them come and live at home with you, because should you pass on, what's going to happen to that person? So what you want to do is try to get them to be able to live on their own independently. And that is really important. Plus, it gives them a value for themselves that they can do certain things. Success is very important for a person with mental illness, because a lot of times they get very depressed. Like, what's the sense of living? I can't do anything. So you want to try and get them involved, volunteering, doing little jobs. They have these I guess it's like a manpower type job or whatever, where they'll get a text and it'll say every day, well, we've got such and such. Would you like to do this? And they can say yes. One of them is you go to Hollywood, down in Hollywood, and you sit as a in the audience because they need to fill those audiences. And as one person said, that was a great job. At the time, this was a long time ago, getting $9 an hour, which was pretty good. And all you had to do was sit there and watch. They'd hold up the car, laugh, smile, applaud, whatever. That was the easiest one. And one of the patients ended up being on one of those judge panels and they paid him for it too, where he was supposed to be the indigent hit by somebody with a car and broke his arm, and he was suing the person who hit him, lost his lawsuit because he was too wild in the court, but played a beautiful part, played that part well. So, but there are a lot of little jobs that they can do to make people feel successful and that they have value. And that is very, very important. Also, when you're determining where a person goes, a flight risk. If they are flight risk, you.
Uh-oh. I think we just lost Gail.
Yeah.
Did you want to step in, Jim?
Sure. So it's just, she was saying that conservative.
Okay.
Are you there?
Yeah, go ahead.
No, you cut off there in your
Oh, I'm sorry. Actually, I've been cutting off a lot, but
Yeah.
you and DeAndre were talking, so y'all never did. I'm sorry. Where did I cut off, Jim?
But just before the
Yes, I am again.
just at the very end of it says conservatee may skip a facility and go to a less restrictive.
Oh, yeah, I was saying home, and if I'm being redundant again, I don't know. But you try not to take them home if you can, unless there's a good reason, because you really want them to stand on their own 2 feet and get like a little job or something, or volunteer, but something that makes them have value and feel important about themselves. Okay, that's it. Next slide. Uh-oh. Next slide.
There, Sally? There we go.
There we go.
All right.
Okay. The doctor can request the court remove you as a conservator. If you are unreasonable, if you are saying we're going to do holistic medication and I'm not going to have them take that medication, the goal is to get them on the road to recovery, and the doctor may have to request that you be removed as a conservator. If you're not doing a good job, if you are doing things like I had one, well, I didn't have them, but one girl had heightened sexual delusions, and her mother gives her the book to read on 50 Shades of Gray or whatever that book is. The doctor said, I don't think you're the best conservator for her, and had her removed. But there are little things that can make a difference. You can also change the treating doctor. If you have a doctor, and we did have this happen, the doctor told the mother she was just highly aggressive. All medications are the same. It doesn't matter what they're on. Well, she changed the medicine. Actually, it was to Invega. The girl has now retired from working for 20 years and did so well. And prior to that time, she was standing in the middle of the street in the middle of the night because she couldn't go to her apartment because there were dead people in her apartment. And she had knives all around her bed to protect her from those dead people. I mean, it didn't make sense to me, but when you get a treating doctor that has bizarre thinking, use your common sense. You've got it, use it. And don't be afraid to say, no, I think we're going to change doctors to somebody who's more receptive to helping my loved one get better. That's what you want. Anybody want to add anything?
No, I agree with you. My conservatee some years back was in a setting where they did not utilize doctors. They were utilizing nurse practitioners. And my conservatee was not doing well on the medications, and this was continuing, and I requested that they consider changing the medications, and the nurse practitioner said, well, I was trained that I have to have my patients on this medication for this period of time before I can change and try some other medication. So I let her win the argument, and I just changed the doctor. And then we got them on a medication that was more effective. So just know that you can change doctors. You don't have to be stuck, but you don't want to lose your conservatorship, you know, by getting into some sort of contestment with the doctor and you know, getting into an argument about the medications and not agreeing with the doctor and that type of thing is a good way to lose your conservatorship. So just change your doctor.
Yeah, and I would like to add something to this. Put your money away. I mean, don't be so willing to bring out your money. The moment you start doing that, you're going to be sucked dry. There goes your vacations, your retirement, everything. Put your money away. They are over 18, and there are enough resources that you shouldn't have to do it. Now, if you're in a situation like Jim was with his son, then you can, you know, at that point, if you're changing doctors and you're getting a really good doctor, I mean, they're really good. I would probably spend my own money on that, on a good treating doctor, but not until you have to. So if you say, oh, well, I can pay for like Betty Ford's treatment facility, I will tell you their success rate.
Uh-oh. We lost Gail.
Do you
Well,
want me to just
I will just add to this that you know, Gail used to have meetings, live meetings. They were fabulous up in Los Angeles at one of the hospitals up there. And oh gosh, hold on here. Anyway, I'll just let it go out there. I won't bring it up. I think we're in trouble on this slide. Let's
Okay,
go to Araceli.
I think I'm going in and out, so I'm only hearing every word. Yeah, I'm sorry about this internet. This won't be like this next time, I hope. All right, next slide.
There we go.
Okay. Oh, DeAndre?
Yes. So some of the rights that a conservatee loses when a conservatorship is granted is they lose the right to drive a car, or we could temporarily restrict the rights of conservatees to drive a car, to enter into a contract, to determine where to live. Some of the more permanent restrictions for conservatees could be the right to possess a firearm. In the Welfare Institution Code, one of the other restrictions that could be imposed on the conservatee is the right to vote. But here in LA County, we, and both us and the courts, we don't really impose that restriction. These restrictions are restrictions that we get that are informed by the doctor that is referring this individual for conservatorship. But once the conservatorship is in place, if these rights have been restricted, then that means that there is no contract that can be signed. I've had a client try to enter into try to get a new cell phone, and he couldn't enter into that contract because he was on conservatorship. That contract was voided. So these are just some of the rights that are lost by the conservatees. Next slide.
Well, I'm just going to add something on that. While a person is under the conservatorship, you can get that right to drive a car, enter contracts, and to determine where they live. Yes. Now, if the public guardian's a conservatorship, they don't tend to want to give them those rights because that's kind of a little bit of a responsibility. but they can. We've had people get married under the conservatorship, driving cars and living in their own apartments and still under the conservatorship. So it does happen. And I think that right to possess and shoot a gun, I think that's a federal thing for 5 years. I could be wrong on that.
I'm not sure on exactly how long, but I'm
Yeah,
not
I think it's 5 years after they're off the conservatorship, but I'm not positive on that. I really not. And the right to vote, I think that turned California. I think that was California made that decision, not just Los Angeles. I think
Yeah.
that Los Angeles started it, but I think California followed through
Hmm.
on that. I could be wrong, but okay, next slide.
Well,
Do you want me to take this, DeAndre?
yeah.
Okay.
because because
If
we
you,
don't
if you
like
are the conservator, and we've done this many times, the right to drive a car, what you do is you give the doctor a written letter stating that you feel your conservator should be able to ride, your conservatee should be able to drive. Then the doctor will fill out a form. It's in that booklet when you become conservatorship, a conservator. It's in that booklet. You give it to the court and they approve them the right to drive. Now, DMV will probably evaluate the conservatee and approve their right to drive. And it's not a big deal that they do. They just ask them their name, rank, and serial number. Okay, you sound pretty okay. You can drive. So it's really not a big deal. They can also get back the right to enter contracts. If they have a job where they have to enter contracts, that would be important. In some cases, if they're getting married, they need to be able to enter that contract. If they don't have these rights, and let's say they're signing for contracts for charge cards, you can call the charge card company and sorry, they can't collect. They're out of luck. And one more thing on that charge card. If they owe money to the charge cards and they stop paying, after 3 years, that would be probably a judgment would be filed against them. But after 3 years, that is gone. It goes off their record, their you know, credit report. So I wouldn't get too anal about something like that. All right, Jim, did you want to add something?
No, I think it's sufficient. We've covered it.
Okay, next slide. Renewal of the conservatorship. Boy, DeAndre, we're throwing you a lot of things.
So the renewal of the conservatorship is the best practice is to do it early, 3 months before the conservatorship terminates. So um, for the for my office, we received notice um, that the conservatorship is going to terminate from the court, usually 3 months before the termination by law date. The problem that my office has is that we have over 1,800 people on conservatorship, so it's really hard to track. But for the private conservators, keeping your home address current with the court and is vital because these notices are issued by mail. When you receive this notice, you then have to start the renewal process. So if you have a court appointed attorney, they should also get a copy of this notice and just let them know we want to continue the conservatorship. In order to continue the conservatorship, you will need a declaration stating that the person remains gravely disabled. Each conservatorship period is at that previous year. You can take into account, you can account for the history of the previous conservatorship and the history of the individual, but the declaration stating the person is gravely disabled, the primary focus of the court is, are they currently gravely disabled? And you can add in um, the historical history in there as well. Uh, I don't know if I'm not sure if LA County. I know we've had dual conservators in LA County, but that we don't recommend that too frequently, unless it's like mom and dad both acting, in best interest of the client. But having like brother sister act as conservator for their other brother or sister, it's from my experience, it can become kind of difficult if they don't agree on best approach. But that's just LA County.
Okay.
So I would like to chime in on something.
Yeah.
Is that here in Orange County, the forms that are necessary to fill out, especially like the doctor's declaration form, is all up on the court's website. And for those of you that are from Orange County, you can call me. Again, I think that Araceli has put our phone numbers for contact up on the website here. I can also provide you with those forms. And as DeAndre was saying, it's really important to start this renewal process 3 months early. But what happens if, in fact, you just forget and you come in at the last, month or the last 3 weeks before the conservatorship expires, and you get a doctor's declaration and you take it down to the court? What will happen is that the court hearing date here in Orange County will actually go past the end date of the conservatorship. So even though that theoretically your conservatee is no longer on conservatorship, the courts will hold that conservatorship in place until the hearing actually transpires and takes place. So it won't be the end of the world, but it's not a good practice. You just want to make sure that you set up a calendar, especially like in your cell phone, if you have a calendar, something to remind you that, hey, it's time to get the forms, it's time to start this process going. It's really, really important. So be sure to do that. Okay, I think that's got it.
Okay. DeAndre,
Yeah.
in our place, if you miss the deadline on the conservatorship, it's done. Is that correct in Los Angeles?
Yes.
Wow.
If you miss the termination by law date and your petition is not filed prior to that date, then yes, the conservatorship would be terminated. I have seen with Judge Herron, I have seen him um, uh, have some conservatorships um, put back on calendar to allow that filing, but um, and the Welfare Institution Code book is huge, and there is a code somewhere in that book that says that this can be done. I just haven't. I have no experience in actually, getting it done, but he did it based on a code in the Welfare Institution Code that where if you miss it by like a week or two, there's some wiggle room there.
Really?
But but again, I don't know how that works in practice, because the public defender would easily have an argument that this conservatorship's done. Like
Right. Because when I did read the Welfare and Institutions Code on that, and I never came across that. And then when Jim told me that happened in Orange County, I said, wow, not in ours. They dismiss it. That's it. And,
Oh, yeah.
so, okay, I'm going to have to read it again. All right. Bedtime reading to put me to sleep. Gravely disabled. DeAndre, you want to start?
Sure. Grave disability is basically if an individual, as a result of their mental illness, is unable to provide for their food, clothing, and shelter. Um, the the key part that I stress to my staff is as a result of their mental illness. So simply because someone is unable to secure housing or food or clothing doesn't necessarily make them gravely disabled unless we can tie that into their mental illness.
Mm-hmm.
It is that's one of the reasons why the burden is so hard to prove on some of these conservatorship cases is, you see someone not taking care of their basics, but if they can verbalize a plan to do this on their own and it doesn't appear to be impacted by their mental illness, then the court lets them go. So our job is we really try to tie in the symptoms of their illness and show how their symptoms of their illness is preventing them from obtaining their basics.
Okay,
Um,
I have a question. Did
yeah.
they take off? It says, but if someone else provides this, they are not considered gravely disabled. On the new code, which starts January 26 in Los Angeles and Orange County, I believe, did they delete that section?
I do not think they deleted that section. Um, I do not believe they deleted it. Um, if someone is able to provide the basics, that could make a person not gravely disabled. But again, the part that has to be also addressed is their mental illness. You know, if their
Right.
mental illness is preventing them from obtaining their basics, um, then and you have someone that is able to give you food, clothing, and shelter, but unable to address their mental illness, then that's someone that would not be an appropriate um, alternative to a conservatorship per the code. So,
Mhm.
but yeah, with family members who often say, "Oh, well, they'll always have a place to stay, therefore they're not gravely disabled." That's that's not a reason to not conserve someone, if that makes sense.
That does, because people were told many times you have to put them on the street. And I always say, don't do that, because it's easier to get the police to your house to put them in the hospital than, oh, so where are they on the street? You don't know.
Yeah,
And plus they deteriorate really fast on the street.
yeah.
So that was the one thing that drove me crazy. And coming from Florida, the difference is they say, if someone has to provide your food, clothing, and shelter because of your mental illness, you are gravely disabled. And if you think about it, every place they go, even on the streets, they can get food, they can get shelter, and they can get clothing. Now it depends on how they deal with that. But, and if you read that Gravely Disabled with Connie Drexler and I wrote it together
Mm-hmm.
on that paper that we have, clothing, if you wear your clothes for long periods of time, or you take them off at inappropriate times and places, or dress inappropriate for the weather, that
Mm-hmm.
covers it on
Yeah,
that. But I like the idea what you said, that if they cannot provide the mental health treatment, the family, they're gravely disabled, even though they're providing all that.
yes,
So that makes the best sense.
yes.
Okay. The court renewal court hearing.
So, court renewal hearings. So once the conservatorship is at the renewal period and your petition's been filed to renew the conservatorship for an additional year, the client still has a right to either a court or a jury trial. In most instances, the clients or the conservatee would request a court trial if they're going to be assigned a public defender, and the public defender knows that these are the client's options, so they can request a court trial or a jury trial. If their client is somewhat stable and able to kind of verbalize a plan, the public defender may go the route of a court trial. And a court trial, it's a trial by judge where the client has to convince the judge that they're no longer gravely disabled and should be released off conservatorship. If the conservatee requests a jury trial, it is exactly that. It is a jury trial. There's a jury trial setting where their evidence is presented to show why the person is still gravely disabled. There's a jury selection, and then on a separate day is the actual jury trial itself, where the client's evidence and the petitioner's evidence, which in this situation would be the family member, you would have to present your doctor at this jury trial to testify in order to reestablish the conservatorship. So it's a very, very lengthy court process and if the renewals go in this direction. But if the conservatee simply says, I'm fine remaining on conservatorship, it's a simple submission and the conservatorship would be renewed.
That jury trial is difficult because you have to convince 12 people to agree to continue the conservatorship or to place them on it if that's what they decide from day one. And selecting a jurors is very difficult because if you have a Scientologist on there, you're not going to get the conservatorship. You can't ask people, are you a Scientologist? But you can ask other questions around that to kind of alleviate the probability of having a Scientologist on that jury. Or
Oops.
I can chime in on one of the.
people
I think she cut out again. I mean, one of the major issues with the jury trial is that the the amount of information or the evidence or type of evidence that the jury trial can consider is so limited in the court rules around jury trials for conservatorships. So, for example, the person's history, overall history, is not a part of, is not information that the jury trial can consider. They would only be able to consider the past conservatorship period. So what happened that led to the person initially being placed on conservatorship may not be a part of that jury trial. So it's the jury instructions are very limiting.
okay, I think I went off, but that's okay.
Yeah.
All right. Next slide.
So if the conservator goes AWOL, you want to file a missing persons report. You want to give a copy of your conservatorship paper to the police. And any person with a serious mental illness goes to the top of the missing persons list under missing children as a dependent adult, and it does not need to be under conservatorship. It's only happened to me once, but I actually had a mother contact me from out of state. Somehow she heard of me through probably this type of a program. And her son, who had several degrees in biomedical, he's a graduate of, I guess he had several degrees, went missing, and he was in extreme psychosis. When she tried to file a missing persons report from Texas to the Anaheim Police Department, they refused because she wasn't living here in this area. I had another chief of police then on her behalf step in that I brought to the fold, and he contacted that police department and said that she has every legal right. So even if you're out of state, you can still file a missing persons report. Some of the things that are problematic is that when you find the individual, the police may come across this individual out in the public arena, and because of their behavior, stops that person and talks to them and determines that something's not right here, is looking at maybe they've committed a minor crime or something. And when they look the individual up, their name and that type of thing, they find out that they're actually a missing person and so forth. They won't hold them. Even if the mother has contacted that police department or the family contacts the police department, they're not going to hold them. They say, they're a missing person, and now that you know where they are, they're no longer missing. So they don't hold the person, and the person goes right back on the street. But at least you'll know where they are. You'll know that they're still alive, and that's really a hard thing to deal with. If you go to Outpost for Hope, some of the information that they'll provide you talks about, collecting DNA. And Gail always says, yeah, if you have hair samples, keep it in a clean paper envelope. Don't seal it, that type of thing. If your loved one goes missing, there's tens of thousands of missing John Does that show up in graveyards across our country, from shore to shore. There's so many people, just John Doe, that gets buried in a place. And one of, well, I promise not to tell, but there was a case where um, the conservator actually found out that their brother was deceased after being missing for so many years. They were contacted. There was a um, gentleman who was in charge of the person that they found deceased and did the good just can't talk today, excuse me, good due diligence in finding out who this person was and was able to contact the family and let them know that they were deceased. But far too often, we don't know where they went. So I would recommend that everybody go to outpostforhope.org and look at the information there. I think it's very, very vital that you have that information. Gail, do you want to add to that?
No, I think you covered everything very well.
Thank you. Okay, DeAndre?
Okay. Did we lose him?
I don't know. DeAndre, are you still with us?
He's
I
muted.
don't.
Sorry. Yeah.
Sorry
There we
about that. I muted myself. I was answering a question in the chat, so I didn't want my typing to come through the screen. But leaving the state of California, so the LPS law is specific for the state of California. Um, if let's say, for example, your loved one was able to AWOL from their facility, like Jim just covered, and went to Vegas. Our conservatorship powers are limited to California only. So in Las Vegas, we would have no real authorities to have that person hospitalized in Las Vegas. Um, for clients who wish to leave the state with family members we recently had a client who had a family member that they had a funeral, and so we needed to go to court to give them permission to leave the state of California with this family member in order to attend the funeral. The rest, I'm not too sure about the reciprocity situation, Gail.
We don't have California does not have reciprocity with other states. East Coast states tend to have a lot of reciprocity with each other, but in California, you don't, not with any state that I am aware of. But I do have a question.
Yes.
When the court gives permission for someone to leave, and let's say something happens, they don't have any authority to get them back, do they?
No, they don't. So
Uh,
before the court grants that permission, they're going to want to know, is the person safe to leave? Is it appropriate, and are they stable to leave? So in our situation, our conservatee was stable enough and redirectable enough to where there weren't really too many risks or concerns about this person, you know, wandering off once they left the state.
Okay.
So that's the one part. I mean, kind of glossed over it, but um, you need court permission, and in getting court permission, you need to show that this is going to be safe and that the client is ready and appropriate to go out of state. It's very similar to even authorizing a pass, to leave the facility. Usually, it starts off an hour or two, but as the person shows that they can manage themselves and redirectable, then the court is more likely to grant that. I have heard of judges reaching out to other judges in California. I haven't seen it happen, and I haven't seen, another judge reach out and actually successfully get the client back. But I have heard of judges that are communicating with other states when they have clients that elope and things like that and leave to other states. So
That's good. Okay. Next slide.
So I want to take time here to thank everybody for your determination and endurance to help your loved one. And when you think you've had enough and you just can't take any more, you can still give 10% more. That's the Navy SEALs model. But the Navy SEALs haven't walked in our shoes or on our road, that's for sure. You need to stay strong, take care of yourself. You are your loved one's strongest chance for recovery. It's really hard sometimes to fight depression yourself as a conservator. And you need to, get help if it's just becoming too overwhelming to you. Take a break, get help from somebody. But, if you stop and think about it, if you were to get on an airplane with a young child, maybe, 5 years old, sitting in the seat next to you, and the cabin of the plane were to depressurize and the masks fall down, the instructions is for you, the adult, to grab that oxygen mask and put it on your face first. Because if you try to put it on the face of the 5-year-old, you may lose consciousness and then both of you are going to run out of oxygen. So you always have to keep yourself strong, oxygenated, so that you can best take care of that child. And this is a very similar situation where you're taking care of maybe an adult, but they're still needing your help, making sure that their life is staying intact and doing well. So you have to start that by doing well yourself. So get help, stay up, share with somebody, hey, I'm not doing well. Don't sit there and suffer with this. And I guess I just want to thank all of you for what you're doing for your own families. So next slide.
Your favorite.
Gail knows I hate to ask anybody for money. I guess it's just I don't know, it's always been my hang up all my whole life. But anyway, it takes funding that's above and beyond the normal to do these programs, to pay for the cost that NAMI actually incurs. And so in that regard, if you can consider donating to NAMI for the continuation of meetings like today's meeting, it would be immensely appreciated. And you can, simply write in at this address. Again, you can do a screen share as I taught you earlier, or you can go to the internet and look up NAMI Urban Los Angeles if you don't have time to catch this address. But send that in, and then please, when you make your donation, let them know that that donation is going to be focused for the LPS Conservatorship program. Okay, thank you all for this. And on last note, I want to say, gosh, some folks are on Social Security. You're retired, and today's cost of living is just out of control. Please don't contribute anything at all to this program if it's going to be a hardship on you. You're trying to live from month to month on what you're getting. Don't donate. But if you can, it would be immensely appreciated. All right, next slide.
That's it.
That's
Okay.
all, folks.
Any questions?